Hello friends. In the last video of Indian Contract Act, I covered regarding agreement and contract, the difference between the two, and essentials of contract. Apart from it, in the other video, I talked about the classification of contracts. And in this video, I'll be covering a very important aspect of Contract Act, that is the two terms. One is offer, termed as proposal, and the other one is acceptance. So this will be the main focus for this video, that I'll be covering each and every aspect related to offer and acceptance as defined in the Indian Contract Act 1872. So first of all, let's start with the offer part. It is defined under section 2 subsection A of Indian Contract Act, which reads as, when one person, I'll just keep on noting the important points of this definition, when one person signifies his when one person signifies to another when one person signifies to another his willingness to do or not to do, his willingness to do or to abstain from doing anything, with a view to obtaining the assent with a view to obtaining the assent of that other person. That means एक पर्सन अपनी विलिंगनेस बताता है दूसरे पर्सन को टू डू और नॉट टू डू समथिंग ऑफ दैट अदर टू सच एक्ट और एब्सटिनेंस दैट इज टर्म्ड एज अ प्रपोजल. तो यहाँ पे जो सबसे इंपॉर्टेंट चीजें हैं, मतलब जो डेफिनेशन अंडर सेक्शन 2 सबसेक्शन ए है, उसमें सबसे पहली बात विलिंगनेस ऑफ वन पर्सन दैट शुड बी कन्वेड टू द अदर पर्सन. अपार्ट फ्रॉम इट, the person cannot make an offer to himself. Do take a note of it, that the offer or proposal is the starting point in the formation of a contract. Like in my first video, I discussed about the difference between agreement and contract. So do refer my first video to understand the difference between whenever I use the term contract. That means it was an agreement at a particular initial stage, plus it has certain essential elements. Now let's discuss the definition as given under Indian Contract Act. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence. So here I would talk about the keywords of this definition, that is, when one person signifies to another his willingness. So here we are talking about the willingness of a person which he signifies to the other to do or to abstain from doing anything with a view. So what exactly is the outcome? With a view to obtain the assent of that person. So here the main important point is that one person signifies to another with a view to obtain the assent. A person cannot make a proposal to himself. One point. Because the definition says when one person signifies to another. So there needs to be some other person to whom a particular proposal is being made. The other part being offered to himself with the object of gaining the consent of the other person. So why he is making that particular proposal? To gain the consent of the other person. So proposal could be made to a single person. It could be group of persons, right? For this, there is a very important case law, Carlyle versus Carbolic Smokeball Company, and let's discuss about the case law. There was a Carbolic Smokeball Company. Through an advertisement, they offered that a reward of £100 would be given to a person who would use the smoke ball 3 times daily for 2 weeks, according to the printed directions. Right? It was given in the advertisement. Anyone who uses the smoke balls 3 times a day as per the given direction, in case the person contracted influenza, he would get a reward of £100, and the same amount was deposited in the bank There was a lady, Mrs. Carlyle. What she did, she used the smoke ball according to the directions of the company, but contracted influenza. So in this case, it was held that she could recover the reward amount because the advertisement was not mere a invitation, but it was actually a offer to the public at large. So finally, it was held that Mrs. Carlyle would get a reward, which was announced by the company, as this was a sufficient acceptance of the offer made in the advertisement. Now let's discuss about the essentials of a valid offer. First of all, it must be certain, definite, and not vague. That means whenever an offer is made, it should be on certain terms and conditions and it should be definite. For example, a person A, he wants to sell a car and he offers B that I want to sell my car for in between rupees 2 to rupees 2.5 lakh. That means the condition is not certain at what exact amount he wants to sell the car. Second point, communicated to the offeree. That means whenever a person he offers something, he should communicate it to the offeree. So that needs to be communicated to the person to whom he intend to offer. Right? For this, there is a very important case of Lalman Shukla versus Gauridat, which I will discuss later in this video. Now, the next point is offer may be conditional. That means a condition can be imposed in an offer, but the condition should not be not against public policy. Right? A condition may be imposed, but it should not be one which is against the public policy. For example, a person X he delivered certain goods to his tailor. When he signed a note that I will deliver the goods back to you 10 days afterwards, X found out that on the receipt it was written that in case of any loss of goods, Y will be only responsible for 20% of the cost of the goods. So this is not a proper condition which is here. It is not justifiable. So the condition should be justifiable. Next is it should be capable of creating a legal relationship. Like in my first video, I talked about that a friend he called his best friend on dinner. This is a social obligation, but if he is not at home, the other party cannot sue the friend who called for the dinner. For this, I talked about this particular part in my first video. Now, next part is lapse of an offer. So, a particular offer lapses. For example, if a person dies before the offer was accepted, or the time period lapses, or it could be a sufficient amount of time was given to the person to decide, but no particular response the offerer got from the offeree. The next point being it should not contain undue terms like non-compliance is equal to acceptance. For example, a person X he offered his friend, would you like to sell me your property for rupees 40,000, and if I don't get a response from you, it will be deemed sold. This type of offer it is like the non-compliance of which will be equal to acceptance. This type of offer is not valid. That if you don't respond, I will be deemed that it will be deemed that you have sold your property to me for this much amount. This is not a valid offer. Now for the second point, that is offer must be communicated. There is a very important case law, Lalman Shukla versus Gauridat. There was a servant P and his boss he told the servant to find his missing nephew. Meanwhile, the person he announced a reward about which the servant was ignorant And in the ignorance that his boss, he has announced a certain amount of reward for finding his nephew, he found the nephew and informed X. The facts are that the servant, he was ignorant of the award announced by his boss. He, during that announcement of the reward, he found his nephew. He informed his boss that he found the nephew. Later on, the servant, he claimed the amount of the reward, and it was held that it was actually the duty of the servant to search for the boy. So the offer should be communicated to the offeree. It is acceptance. For this, we have to refer section 2, subsection B of Indian Contract Act. When the person to whom the proposal is made, when the person to whom the proposal is made signifies his assent, that means a person made a proposal. So we are talking about this person to whom a proposal is made. He signifies his assent. It is an acceptance of the proposal, right? So this particular accepted proposal is called promise. It is divided under section 2, subsection B of Indian Contract Act. Essentials of a valid acceptance. First of all, it should be communicated to the offerer. That means if a person has accepted the particular offer, he should communicate to the offerer mere intention, that it keeps on thinking in his mind that I have accepted the offer. It is not a valid acceptance. So the person needs to communicate. Second aspect, it should be within a reasonable time. That means the acceptance should be validly made within the time allowed by the offerer. Like if there is some time period specified by the offerer, it has to be accepted between that time, or in other cases, it has to be made according to the facts and circumstances of the case. Next point being, it should be absolute and unconditional, because whenever an offer is being made by a person to the other person, it has to be accepted as it is, then it will be termed as a contract. Otherwise, if the other person imposes some condition, it will be termed as a cross offer, which would actually lapse the original offer. So, in the case of acceptance, it should be unconditional, otherwise, a cross offer would arise and it would lapse the offer which was offered by the offerer. Next point, it should be as per the mode prescribed. For example, if a person gives the offer that I want to sell my car for this and this amount, but the point is I should get a draft of rupees 1.5 lakh before this and this date. Now, if the person, the purchaser, the acceptor, he gives a check, it would be deemed as rejected, because the offer was made that I need a draft for this and this amount before this date, but the person who accepted it, he gave a check. It automatically gets rejected. Next point, acceptor must be aware of the proposal. That means the offer should be in knowledge of the acceptor that I am accepting this offer on this and this particular terms and conditions. Otherwise, if he is not having the knowledge about the same, it would not be accepted as a valid acceptance. Mere silence is equal to no acceptance. That means if a person offers someone that I want to sell this and this thing, but the person B, he just remains silent, this would be no acceptance. For this point, acceptor must be aware of the proposal. For this, you can even refer the case of Lalman Shukla versus Gauridatt. Lalman Shukla versus Gauridatt. Friends, in the next video, we will talk about the revocation of the offer and acceptance. So, if you like the video, do subscribe the channel and click the bell icon for further updates. Thanks a lot.